Not all injuries are equally easy to prove in a personal injury case. Some injuries are very clear from medical imaging or visible trauma, while others can be more difficult to document. My name is Zach Anderson. I'm a co-owner at 217 Law and an injury attorney in Central Illinois. In this video, I want to briefly just talk about why certain types of injuries can be harder to prove in personal injury cases than others. So generally speaking, injuries that do not appear clearly on diagnostic testing can sometimes be more challenging to establish. This would include things like soft tissue injury, chronic pain conditions, or certain types of neurological symptoms might not always show up clearly on x-rays or MRIs. Concussions, for example, some imaging can show concussions, but a lot of times the symptoms associated with concussions or post-concussion syndrome are really subjective. So those can be difficult to establish. Chronic pain conditions are notoriously difficult to establish because there's so much subjectivity involved in a pain condition. For example, there's a rare injury that's called CRPS, which can be very, very, very challenging to prove because CRPS, for the most part, my understanding anyway, is it does not typically show up on imaging. So the injury, treatment for the injury is really reliant upon the subjective symptoms that the injured person is facing. Another challenge that can really arise is if there's a delay between the incident and the medical treatment received. Insurance companies often argue that an injury was caused by something else or question whether the symptoms are related to the incident at all. I run into this all the time, especially like soft tissue injuries, a neck injury, for example. If someone suffered whiplash in a car accident, but there's a delay between when they actually sought medical treatment for their whiplash, then the insurance company is undoubtedly going to argue that, well, the whiplash could have been, or the neck injury could have been caused by something else. I had an insurance adjuster tell me one time, well, what if the person got injured playing basketball? Like, well, the person that I represent is a 65-year-old female who hasn't touched a basketball probably in, 55 years. So, you really never know what they're going to say. So, um, long story short, if you have an injury, go get treatment as soon as possible. Otherwise, the insurance company is going to typically, will dispute causation between the underlying incident and the injury. Pre-existing conditions can also really complicate injury claims. If someone has a medical issue before the incident similar to the injury that they later claim was caused in the incident, then the insurance company will likely argue that the current symptoms are related to the prior condition rather than being, even aggravated by the accident. Again, run into this all the time, especially with older clients. As we get older, we've suffered various injuries, and um, one of the things that insurance companies love to do is argue that, well, even though the client was in a car accident and the car accident was caused because they were rear-ended by another vehicle, and even though there was a lot of force, the back injury that they're claiming, that's just wear and tear due to being due to their age as opposed to anything related to the accident itself. So those injuries can be a little bit more challenging than a younger than an injury that's suffered by somebody that's younger. Because of all these issues, medical records, consistent treatment, and clear documentation from healthcare providers are important parts, integral parts in establishing the nature and cause of an injury and relating that injury back to the underlying accident. If you suffered an injury in Central Illinois and you have any questions about causation or how any of this might work under Illinois law, please feel free to reach out. Be happy to talk to you.